name's Mary and I'm a solicitor at Neave Lawyers. Just a bit about us. I'm in a team called Workplace Law, and obviously health and safety is the hot topic, but we also do employment, immigration, privacy, all those types of aspects. So that's what you've got in front of you, is just a wee booklet. So today we're going to be talking about the Health and Safety Reform Bill. Now, just out of interest, what do you guys know about this? Just sort of throw some things. Yeah. So it's been hyped up by the media, and rightly so. It is a really big legislative change. What I want to stress to you guys tonight, though, is that don't be too scared off by it. Just because there's an accident or you breach the Act doesn't necessarily mean you will get prosecuted. So just keep that in the back of your mind. I am going to be saying some scary things, but just because there is an accident doesn't mean that you're going to be prosecuted. So try and keep that in the back of your mind. It might ease some of the blows I'm going to give. So this is just, I have a few wee pictures going up. We're actually building a new building down Cambridge Terrace, so my boss wanted to tell you guys that this is the air conditioning unit going in. On that note, Andrew Shaw is the leader in our workplace law team. He would have loved to have been here, and he sends his apologies, but he's actually speaking at a WorkSafe conference tonight on pretty much the same thing I'm talking about. So that just gives the level that we deal with at Neave. We do quite a lot of prosecutions. On the other side, obviously, defending people, and Andrew's extremely experienced in this area. So just some background to the bill. Like I said, I don't want to give you too many scary statistics, but there's no doubt that in New Zealand we have a really bad health and safety record, and this is essentially where it's come from. The catalyst was obviously Pike River, but even putting Pike River aside, we have some terrible statistics. So I'll just give a couple to you. On average, each year, 75 people die on the job in New Zealand. 1 in 10 people are harmed on the job a year in New Zealand. And the government estimates that workplace injuries and illnesses cost about $3.5 billion a year to the country. So that, combined with Pike River, is just a bit of background as to where this has come from. The bill that I'm going to be talking about today, that you're all aware of from the media, is based on the Australian model law. So this was implemented a few years ago. Has anyone worked in Australia at all, or knows anything about the law over there? The people we deal with say, since that things have changed, it's pretty harsh over there in terms of obligations on people, and health and safety managers over there are at the top of the hierarchy because Australia has taken it very seriously, and that's what we're moving towards. So the first reading of the bill was on 13th of March. Now, where all the media reports are coming from at the moment is in relation to the Select Committee report. So what we're seeing is there's a bit of division in the government as to the applicability of the bill to small businesses. No doubt this is of interest to you guys. What I want to emphasise is the difference in opinion appears to be around how the bill will apply in terms of worker participation. So what that means is how you will involve your employees in making decisions about health and safety. What I want to emphasise is you're not going to be exempt from the bill at all. It's only going to be what seems like in relation to worker participation. So that's where the key difference is at the moment. The media is sensationalising it, saying, they're watering down the legislation, blah, blah, blah. But from my understanding of actually what's going on behind that is the government's just simply looking at, do small businesses need to involve their employees in health and safety? So have you guys heard all that obviously in the news lately, and what can I have people's impressions from the media reports? What are you guys getting from it? Is that your understanding as well, or does everyone think that you might be exempt? No. Okay, good. I thought that would be the biggest blow, so I'm glad that everyone's on the same page. So we're expecting the Select Committee to report back at the end of July. From then we will know a lot more, especially the obligations on small businesses. In terms of regulation, so what's going to happen is they're going to put the bill into legislation, they're going to release regulations alongside. Regulations are really prescriptive, and these are going to be the best tools for small businesses to use. They're going to say how you comply with your duties and particular things that specific industries need to be aware of. So what I'm going to give you today is a really broad overview of your obligations. And it might seem a little bit abstract to you guys, but when the regulations come out specifically saying X, Y, Z is what you need to do, it'll be a lot easier for you guys to comply. WorkSafe's actually a really great organisation. They have a lot of fact sheets and things online, and so when the regulations come out, there will be a lot of information available for people as to how they comply with the Act. So first of all, how I'm going to work through it in the bill is basically not section by section, but in terms of the different parts of it. First of all, we'll look at the key terms. So the bits and brackets are what the current Act says, so that's the Health and Safety and Employment Act, and the top heading is what it's being changed to. So this is basically what underpins the whole Act. So the purpose of bringing this in is to provide for a balanced framework to secure the health and safety of workers and workplaces by all of these different things. Now, I don't expect you to read or understand all this in detail, but basically what it's showing is that the current Act, all it's asking people to do is to promote health and safety. What this new Act wants us to do is to secure health and safety of workers. It's such a big change in language, and for us lawyers, you know, it's the automatic thing we picked up on. This underpins the whole Act, the purpose of the Act, and it really shows the direction that the legislation is going in. I will come to it a little bit later, but I will point it out. Are you guys aware of the eliminate, minimise, isolate? Yeah, it's very common under the current Act. What's actually happened in this Act is they've taken out the aspect of isolation, so you see eliminate, minimise risks. I'll come to that a little bit later, but it's basically just taking one step out of the chain. Practically it's not going to make a little bit of much difference, but in terms of moving forward, how you deal with hazards, that's something to think about. So under the current Act, we have a person called a duty holder. Now this is generally what people coin as employers. Under the new Act, it's changed the concept to a person conducting a business or undertaking. Have you guys heard this term at all? So essentially what it is such a wide term that so many people are going to be caught under it. Literally, the legislation says that a person who conducts a business undertaking, whether they're alone or with others, or whether or not for profit or gain, has duties under the Act. So any business owner is going to be caught under this. It's incredibly wide. So if you think, oh, do I have duties or not, you're probably going to have duties. There are exceptions under the Act, volunteer associations, people that work at home, things like that, but they're very, very narrow, and I can't see anyone in this room probably falling under any of them. If you do think you might be excluded from this very wide definition, we can chat afterwards. So the employee, now coined the worker, again, extremely wide. All these people will be covered under the Act. So it's not just a person you employ, it's someone you contract or subcontract to, apprentices, trainees and volunteers. All those people PCBUs owe duties to in health and safety. The legislation is incredibly prescriptive, and we've just pulled out sort of the key ones here, but again, if you think you've got someone in your workplace, they probably are going to be covered under health and safety. And the place of work, now defined as the workplace. Again, it's a much wider definition than we saw. So a place where work is carried out for a business or undertaking includes any place where the worker goes or is likely to be at work. So that covers, when people are travelling to and from building sites, that type of thing. It's not just your physical office presence where you are responsible for someone's health and safety. The legislation also prescribes vehicles, vessels, aircrafts, all that type of stuff. So again, really wide, essentially when they're at work, it doesn't matter if they're at your office, if they're, down at the florist buying your flowers, you owe health and safety duties to them. And notification, so I'm sure you guys are aware of this. When there's an accident, you need to notify WorkSafe of it. Currently, you only need to notify WorkSafe when there is serious harm, so someone hurts themselves quite badly on site. What's changing under the Act is that you need to notify WorkSafe in so many more circumstances. Practically how this is going to work is going to be quite interesting, but what the legislation is saying, you need to notify them when someone has an infection, where work is a significant contributing factor, when someone gets an occupational illness. That's a bit arbitrary, but they literally specify in the Act all these illnesses related to animals, so I'm assuming that's for vets and things like that. And you need to notify them when someone gets an injury or illness that requires them to go to hospital. So what we're looking at now is not simply when someone is seriously harmed, but when they're essentially just harmed in any way at work. The key one is the next one. Like I said, you need to notify when someone is exposed to a serious risk. So again, they don't actually have to be hurt, but if bit of scaffolding falls 5 metres from a person, technically under the new legislation you would have to notify in that circumstance because someone has been exposed to serious risk. Now, you guys are looking at me quite blankly. It's incredibly onerous, and I recognise that. Practically, I'm not sure how this is going to work. WorkSafe are not going to have the resources, for people to be notifying when they cut their finger or something, So the regulations will hopefully prescribe a little bit more as to the exact types of things they want us to notify. But as the legislation's drafted, it's incredibly wide. The purpose of this potentially is that either WorkSafe can look to prosecute in more circumstances, or they're just looking to get more data on the types of accidents that happen in the workplace.
Isn't it enough they injure themselves, they go to the GP, they get ACC? What can ACC?
Yeah, look, isn't that just the thing with every government department?
Yeah.
Why can't they talk?
Yeah.
Yeah, and that, maybe you should go into politics, that'd be great. But the obligation's on the employer to notify. And so I guess it's in small businesses, it's important to have that one centralised person who's dealing with ACC, health and safety, all that type of stuff. So if someone has an ACC issue, then okay, well, we're going to notify WorkSafe if it's relevant. Now, technically, you need to notify verbally immediately, so as soon as the accident happens, as soon as possible, and then in writing 48 hours later. Now, we often become involved at the notification stage because this is the first concrete evidence that WorkSafe will have going forward if there's a prosecution. So generally we do advise getting legal advice at this stage, but I recognise in some situations you're notifying all the time, particularly if there's a death or something where prosecution is almost inevitable. At that point, definitely look at legal advice. Any other questions in regards to notification?
It's not including near miss. Is that what you're saying, or it is now going to include near miss?
Yeah, it is. So near miss, yeah. So technically, under the current legislation, you have to notify only if there's serious harm. I think they do encourage you to notify in near miss situations, but there's no legislative basis to do that. Under the new Act, there is. So yeah, near miss is a good way to coin it. Again, I'm not sure exactly why they want to do it this way. I think it's maybe potentially for prosecution purposes because they can, under this new legislation, prosecute for near miss, which I'll get to a little bit later. Yes.
Can we just stress some mental health issues?
Yes. Please, look, I really don't want to scare you guys, but I think it's best I will be saying the worst of the worst, and this is where the legislation stands. But again, like I said at the start, just because there's an accident, just because you breach the Act doesn't mean there will be a prosecution that follows. But you do need to be aware that this legislation is incredibly onerous. And practically at the end, I'll give you some tips as to how you can, try and comply. Thank you, Deidre. So the legislation also talks quite in depth about hazard and risk. Now, how I define the difference between hazard and risk is a piece of machinery is a hazard. When you put a person near that piece of machinery, there's a risk. So the Act is really moving away from a hazard-based approach to a risk-based approach. They're really looking at the human interface and trying to, protect people, obviously. I don't think the current legislation potentially does that enough. It looks at hazards and tells people to minimise, isolate, that type of thing, but it doesn't address the actual human element that is often involved. Just one thing I'll point out here, hazard is defined as a person's behaviour as well. So remember, health and safety. Safety is only one aspect of it, health is the other side. So from an employment perspective, if you've got someone who's incredibly stressed at work, that could be a health and safety risk. Whether WorkSafe would ever prosecute that, it is, it's something we look at potentially in the future. But just be aware that it's not just, physical things, it can be mental things, and it is specified in there about mental fatigue and things like that. Especially in the building industry, I know mental fatigue is a huge issue at the moment. WorkSafe recently had a conference on it where Andrew spoke just on fatigue. I'm not sure if anyone can provide any comments in the industry at all, but I know that there potentially might be looking at introducing, hours, like they have in the driving industries and things, just because of the long hours that people are working at work and the health and safety risks that they present. Okay. So now we'll go into the key principles of the Act. Is there anything in terms of the definitions that you guys want to question at all? I guess the key thing to take from it is the definitions are really wide and they're going to cover a lot of people, a lot of acts, a lot of things. Okay, so have you guys heard of the test all practical steps? Yeah, so this is essentially the cornerstone of the Act as to what you're meant to do in terms of health and safety. What it currently is all practical steps. It's moving to reasonably practical. So what that means is when you are undertaking a health and safety action, have you taken reasonably practical steps? So that means, what reasonably practical means is, weighing up all those factors here. Have you done enough to protect the health and safety of the people that you're responsible for? I've put this under a principle, but it's more of a definition. It applies through all the duty holders. As a PCBU, you have to take reasonably practical steps to look after your employees. Now, what's reasonably practical for one business is going to be reasonably practical for a different business, but this is what WorkSafe will look at if you have an accident on your site. So the key one we look at is the costs associated. So if you're $1 million company and it costs you $50,000 to get a cherry picker to do a job instead of, a ladder, for example. Sorry, I'm really not good in the construction industry, but that's an example we use. Potentially, if there was an accident because you didn't use a cherry picker, and that was more appropriate, they might look and say, you should have paid that extra money to get the cherry picker in for that job. But if you're only a $100,000 company and it costs $50,000 to get a cherry picker, then that's probably not right where the mark is at. So it is a bit of an arbitrary test, but it takes into account your specific circumstances as to what you can do in the situation to reduce health and safety risks. So again, this comes back to here, the duty to manage risks, which used to be called hazard management. So this shows the difference between the hazard and the risk approach. Basically, under the Act, if you're a duty holder, you have a responsibility to manage risks by either eliminating the risk or minimising the risk so far as possible. Now, by elimination, we mean getting rid of the risk. So at a very simple level, you have a box in an aisle that someone can trip over, you move the box. You've eliminated the health and safety hazard. Minimising it, you would either potentially rope it off, put up a sign, that type of thing. So those, at a very simple level, is what elimination and minimisation of health and safety risks are. And you guys in your separate industries will know exactly the types of hazards. Things will pop to mind when I'm saying these types of things, and you'll know, what you can be doing to fulfil your duties under here. Sometimes it isn't practical to eliminate a risk, and that's why there's that second tier down to minimise it. Minimising, is really about training, supervision, signs, all that type of stuff. And it's really hard for me to give, specific advice as to what you can do, because it really just depends on the types of risks that you guys face in your industry. So other key principles about duties, which I'll get into the specific duties next. A duty is not transferable, so you cannot, if you hold a duty as a PCBU, you can't simply hand it on to someone else, it's always there. A person may have more than one duty, so I'm going to talk to you a little bit soon about officers. So they're essentially directors and things like that. You can hold a duty as an officer and also hold a duty as being a PCBU. Importantly, more than one person can have the same duty. So for example, like I said, a PCBU and an officer might hold the same duty. Most importantly for you guys is this duty to consult with other duty holders. So the example I use here is when you're on a building site, there's so many different contractors, subcontractors. There is actually a duty for all those people to consult with each other on health and safety matters. In practice, I think this is going to be one of the best changes to health and safety in New Zealand, that actually people working in high risk areas need to consult with each other about how every single person is complying with their health and safety obligations. And obviously you cannot levy workers for health and safety. Okay, so the duties. So what I've given you so far is the definitions in the Act, the key principles that apply to these duties I'm going to talk about, and now we'll go on to specific duties held by everyone. So the primary duty of care under the Act is held by the PCBU. So the PCBU must ensure as far as reasonably practicable the health and safety of the workers. So that's when they're carrying out work for you guys. Specifically, they must also ensure that other people are not put at risk as a result of the work carried out. So that's quite a wide duty. That's looking after your workers and also making sure that anyone visitors walking around the work site, being around it, are not harmed also. There is a lot of specific criteria named under the Act as to how PCBUs can comply with this primary duty. For example, some of them, you're meant to give safe systems of work, provide adequate facilities for the welfare of workers, give training, instruction, all that type of thing. It's quite prescriptive, but again, it's all very broad and fluffy, and when the regulations come out, hopefully it's going to give a lot more direction as to how PCBUs comply to keep their workers safe. Outside this primary duty of care to look after your workers, obviously take all reasonably practical steps, minimise hazards like I talked about before. There's duties on people who manage or control workplaces. This is already an existing duty under the Act, but it's put in there again. There's also duties on self-employed people, which I won't go into unless you want me to afterwards. And also duties in terms of PCBUs who, manufacture fixtures, fittings, control plants, substances. There's a lot of words up here, and I appreciate it's quite overwhelming, but what I can generally say is that the extensive provisions at the bottom there, that's really specific duties to PCBUs who manufacture all that type of stuff, and I think that's why WorkSafe have specified it, because that's where the real risk is in terms of factories, machinery, all that type of thing. But regardless of the specific duties at the bottom mentioned there, there's always that primary duty of care for PCBUs towards your workers. Now, duties of workers. So yes, your employees do have health and safety duties also, like you mentioned. So like I said, the worker definition earlier is much wider, so a lot more people will be covered under it. So when we talk about workers, we're talking about contractors, subcontractors, all those type of people as well. When they're on your building site or you've contracted them to do work for you, they actually have duties themselves to look after themselves. So they must take care of their own health and safety, and they must ensure the acts that they do not harm other people, and they must cooperate with reasonable instructions. Now, coming back to what you're saying, some employees have been prosecuted for not complying with their health and safety, but it is very rare. Generally, the fault is pinned on the employer. The reason for that is, WorkSafe have found that the employer hasn't properly trained the person in health and safety, things like that. So one example, I'll give you a very extreme example, it was the case of South Pacific Meats, and what happened there was that an employee turned up high to work. He was operating a shank saw and he cut his finger off. Now, most people would think, come on, it was his fault, he did it, he turned up high, he wasn't fit to work. WorkSafe actually declined to prosecute that, but the Engineers Union brought a private prosecution, and the court found that adequate training and supervision wasn't given to this employee, so they hadn't met their health and safety duties. Yeah, that's a very extreme example, but that just shows the level of onus that really is put on employers. It's not a defence to say that, the employee is just not good enough, it was all their fault. And so, like I said, practically to deal with that, if there's any health and safety issues, where reasonable disciplinary procedures are advised, because health and safety, it's not just putting themselves at risk, it's putting the company and others at risk. And quite interestingly, in the new Act, we've got duties of other persons at workplaces. Now, we think this may apply to visitors, so people who visit your work site will also need to take care of their own health and safety. I won't go too much into detail into this, but I mean, for example, if you have clients coming for tonight, for example, we're visitors to this workplace. We have to take care of our own health and safety, and potentially Ashton Wheelans also have to care for our health and safety. So.
That's a no more alcohol. Breath tested on the way out.
Okay, so officers, have you guys heard this term coined recently? So this is probably the biggest change under the Act. So basically an officer has a duty to ensure the PCBU complies with its obligations. So as you'll see, an officer includes all these people here: director, partnership, limited partnership, body corporate or unincorporated body. So it's a huge amount of senior management essentially. And there's a catch-all. It's any person who's involved in decision making with regards to health and safety that affects a substantial amount of the company. Now, I don't think for you guys it'll matter a lot, because if you're small business owners, all of you will be officers. You know, you're the director of your company, you're the CEO of your company. But for big corporations, this is a really concerning aspect, because there's directors and boards on the top that have no idea what's happening on the day-to-day running, and they could potentially be personally liable for any deaths or anything that happens in their workplace. So this has shaken up a lot of big companies, and as a result, they're really taking health and safety and putting it to the next level in their organisation. It's funny that happens when, prison sentences and things become a possibility. So I'll get to that soon. But, this isn't surprising in the wake of Pike River that, officers should be personally liable. So the duty on officers is that they must exercise a thing called due diligence. Now, any of you that have bought and sold businesses will know what this means. Basically, what they have to do is they have to take reasonable steps by doing all these things listed here to ensure that the PCBU is complying with its health and safety duties. So what I see this as being in big businesses is a huge paper trail. Health and safety is talked about at the board meetings. The board members go down and check the work sites. They make health and safety a top priority. That's essentially what we see as due diligence being. Okay, so I'm going to go quickly through this because this is the worst part. Offences and penalties. So generally, the maximum level of fines has gone up 5-fold. Now, this is the worst category. So this is reckless conduct in respect of health and safety. So reckless conduct is where basically you're aware of a significant risk and the potential consequences, and you proceed anyway. So a corporate, the potential fine is 3 million. An officer, this is personal liability for an officer, 600,000 and/or 5 years imprisonment. For an individual, $300,000 fine and/or 5 years imprisonment. So it is a lot of money. In terms of penalties, comparative and other acts, I haven't come across anything as high as this. Just because that's the cap doesn't mean that's what's going to be fined. What we see under the current Act is there's a $500,000 fine and 2 years imprisonment. No one, to my knowledge, has been put in prison. I'm not sure why that is. There hasn't been any potential things bad enough. We have had a director get some home detention recently. But with the current Act being 500,000, there's tiers in terms of people's culpability. So, I'm not sure of the highest fine to date, but I don't think it has been anywhere near $500,000. So in saying that, if we apply that to the new Act, while $3 million is the top, I would see it very unlikely that anyone would ever get fined $3 million. So, for example, what may come under this is if someone puts up scaffolding on a site. Again, apologies for using all the work sites, but they just seem to fit nicely with health and safety. And they know the scaffolding's unsafe. Someone goes in it, falls and dies. This is probably where the prosecution would come under this one here. The next one is when someone is exposed to risk of death or serious illness or injury. Now, this is just a risk. No one needs to be harmed for someone to be prosecuted under this. So using my previous example, scaffolding's put up incorrectly. You didn't know it was put up incorrectly and there's been no injury, but it's still been put up incorrectly and it's seen as a risk to health and safety. potentially there could be a prosecution. This would be where it falls. So corporate 1.5, officer 300, individual 150. So no imprisonment here. The key difference with the imprisonment, I think, is that the previous offence you have to have knowledge. You have to know that what you're doing is bad. This is called strict liability. So whether you have knowledge or intention or not, they can still prosecute you under this section.
Would that include your near miss?
Pardon?
Would that potentially include your near miss?
Oh, near miss, yes.
Yes.
Yeah, that's what it is essentially. Yeah, sorry, it's good, I should use this terminology, near miss, yeah. So you're simply exposed to a risk. And yeah, I think this would be the most common one where there's a near miss. If they find that you simply haven't fulfilled your duties, they would prosecute under this. I would say in this one, for example, that crane that fell on Victoria Street, no one was injured. Would you classify that as a near miss? Yeah, probably. There was people around that could have been hurt. That's the risk here, and that's what could have been prosecuted under. And this is just the catch-all. So this is any breach of a duty. Again, like what I've talked about there, it doesn't have to be an accident or anything like that. You can still be penalised for breaching the duty, which is to provide all practical steps to minimise hazards, all those things I talked about before. Smaller penalties comparatively, so there we go, failure to notify notifiable event, if they find that something's happened that you should have notified, then there's instant fines there. Requirement to keep health and safety records, requirement to preserve incident sites, and failure to have worker participation in practices and things. They're just smaller fines, still a lot of money, I recognise. But this is just indicating the types of things that they really are going to focus on. It's not just if you breach a duty, it's if you're not communicating to work safe and all that type of thing as well. So liability. Now, health and safety insurance. Does anyone have any insurance with health in terms of health and safety at the moment? So you can get insurance. But it only can cover reparation and costs, so legal costs in terms of a health and safety prosecution. So reparation is the money that's paid to a family. For example, someone dies, quite common for companies to pay maybe 20, 30, 40, 50,000, whatever, as reparation. So you can get insurance for that. You cannot insure against fines. The purpose of that is that, the legislation will be lost if you could insure against getting a fine. So this is the scary thing for people. It's statutory liability, so you cannot contract out. You cannot contract out via, agreements with people. So, we've had some people come and say, well, can we have a contract with our subcontractors that they're going to have all the health and safety obligations on the site? You can't do that. Everyone has got an obligation in law, and just because you sign a piece of paper with another person doesn't mean that you're not going to be subject to your obligations. And the real cost, we've called this. So like I said, strict liability offences for the last two I talked about. Intention isn't relevant. So whether you intend to breach health and safety or not doesn't matter for those last two. If there has been a breach, then they may look to prosecute. The only defence available is there's a total absence of fault. It'd be very hard for someone to argue a total absence of fault. Because if there really was a total absence of fault, WorkSafe wouldn't prosecute in the first place, so that's why you get lawyers involved at the start, so we can argue that for you. And you've got to look at the total penalty involved in health and safety, so it's the fine, the reparation, the court solicitor costs, and also the other costs, so downtime, workplace culture. I'm not sure if anyone's had accidents in their workplace, but I'm sure it's not a nice thing to be around, and it's not just the legal costs, it's the emotional costs. So that's why it's really important to get health and safety right. Now, this is the hot topic at the moment, worker participation. I'm not going to talk too much about it because it's really subject to what the Select Committee comes back with as to how small businesses will be involved. What I will say is that there definitely will be an obligation on you guys to consult with your employees about health and safety. The level of, or how formal it will be, depends on how the Select Committee comes back. So what they're talking about in the media at the moment is not making health and safety representatives compulsory with businesses with 20 or less employees. I'm not sure if that's going to be passed or not. Regardless of what the legislation comes back with, we always advise it's really good to get your employees involved in health and safety. They're the ones on the ground. They're the ones that know what's going on. If you have a direct line of communication with your employees about these issues and some sort of processes in place, then it can be for your benefit just as much as theirs.
I guess what is considered adequate consultation with the employees? I mean, say for the likes of here, if we were to have like a staff meeting and just everyone give input, I mean, is that considered adequate or?
Yeah, I mean, like I said, this is all the bill says is really broad things, and the regulations will hopefully prescribe a lot more as to, you know, X, Y, Z what you do. For example, in our firm, what we have is we have a representative from each hub, so we have 5 different offices and they meet every few months, and for in an office environment that is adequate. Potentially in something that's safety sensitive area it's not so adequate, but that's just what we've sort of seen is, you know, involving employees, allowing health and safety issues to be brought to the forefront is okay in a law firm doing that, but we're still subject to wait to what the regulations say to see what they do. But it is, like I said, it is arbitrary, and I do appreciate that, but I guess you can never have too much consultation, and as long as you know, formalise it, you have meeting minutes of things and you know, follow process in terms of how if you appoint certain people to them, and, you know, for example, a health and safety committee shouldn't just be made up of all board members or all the top tier. It should have workers on the ground. It should involve all different people. How formal a process that is for small businesses, we'll find out soon. But I still think it's a great tool because, you know, like I said, the guy on the ground knows a lot more than the person sitting in the office. So this is a little bit about why to invest in health and safety. It enhances your reputation as a firm. We've seen recently, I'm not sure if you saw, there was a cleaning company that put an advertisement in the newspaper saying they're taking seriously their new obligations that are going to come into effect under the Act. So companies are picking up on this and seeing that it's a really good selling point, that they're aware of health and safety, they're complying with it. Because ultimately, if you're working with other companies, you both have health and safety duties. And for example, if you're on a work site and, you know, there's a project management company, you know, there's a building company, that project management company wants to, you know, work with the building company who has a good health and safety record because their duties are all intertwined. If there's an accident in the building, one of the building company's employees, the development company could be liable too. So it's really important from a reputational point of view. Reduced ACC levies, reduced sick leave in terms of employees, better productivity and innovation, improved employee recruitment and retention, increased revenue. I guess that could be direct or indirect, getting new jobs because people see you as you're complying with health and safety, you know, you've got a good workforce behind you. Also, if you're not having to pay fines and things, that's good also. And better experience for employees and clients. And there actually was a study by Massey University on this a few years ago, which is quite interesting. If you've got a bit of time on your hands, just search it on Google, and it really does give some good points about not only from a financial point of view why health and safety is important, but also just from a person-based point of view. And so in terms of what we do, like I said, we do prosecutions, and we're really at the crap end of this kind of stuff, you know, when stuff all goes wrong. There are some really good companies out there that can help you from a practical perspective to get all your paperwork in place. Does anyone use anyone currently that they can suggest to the group? Or
For health and safety?
Yeah.
We use Hazard Code.
Yep, and they're good?
Haven't had to use them.
Okay.
Something that's really not.
Yeah, I mean, yeah, because there are companies that come in and do health and safety audits, which are really good. So we recommend Tri-X. They're a little bit at the high end of costs, but they're really good. There's also occupational health and safety consultants, and I can give you details of these guys if you're interested. But what we do is, we do the legal end, but it's really important with this new legislation coming in to get some practical advice from people as to making sure your paperwork, you know, your hazard register, your notification forms, all that are in line. All you can do with this legislation is try your best, and I appreciate it's scary, and I hope that I haven't scared you away too much. The obligations are increased, but as long as you know that you're doing the best you can, you're keeping really good paper trails of all your health and safety. I can't stress that enough, as paper trails. When we have people come to us saying, for example, that worker that was injured in the South Pacific meets, if they came to us, the employer came to us and said, we trained him. Yeah, well, we trained him on that saw, that's fine. Well, where's the training record to show that? That's exactly what WorkSafe want to see. They want to see that you've taken it seriously and you've actually recorded these types of things. So I can't stress out how important paperwork is, and I know it's a tax. But yeah. Thanks, guys.
Thank you.